everyone. Thank you for joining us today for this special extended trade and tariff briefing. My name is Tiffany Yen Louie. I'm the Chief Marketing Officer here at World Trade Center, Utah, and I'll be facilitating today's conversation. It's been a big week. The U.S. Supreme Court heard a major case that could reshape how tariffs are imposed. With this significant event, we're just taking a little extra time today to unpack what it means for Utah businesses. If you're joining us for the first time, welcome. We launched this briefing series in April to help Utah businesses stay informed and proactive in fast-moving trade environment from this past year. Each session, it stands on its own, but if you'd like to rewatch today's discussion or stay connected and watch future briefings and miss them, Andrea's dropping a link to our YouTube channel in the chat for you. We're going to start today with Ben Kolendar, Chief of Staff here at World Trade Center, Utah, for an update on the tariff dashboard. We'll then move to export trends and today's legal deep dive that you guys are all anxiously awaiting, I'm sure, with Maggie Monday and Chase Dunn, who I learned this morning has Utah roots, born and raised, and so excited to have him with us to be able to provide this as well. But they're both with Cassidy Levy and Kent, a leading international trade law firm that's based in Washington, D.C. I'll turn it over to Ben. Screen's all yours.
Thanks, Tiffany. I'm going to share my screen and give my plug for the tariff dashboard as I always do. So if you want to follow along either on the shared screen or separately, you can go to wtcutah.com/tariffs, where you could see not only a link for the joining these webinars, if you want to share that with other folks. Obviously, you know where to go because you're here, but if you want to share it, this is a good website to share. I'm going to start. We get a lot of questions about Switzerland. We did see a little bit of news out about Switzerland today or yesterday that talks are underway with USTR. So we don't have any, detailed updates here, but just to say that we know that there is some discussion of a deal in progress with Switzerland. And just to recap, we see Switzerland as a close trading partner in the United States, generally speaking, but they have a 39% IEEPA tariff that came out as a part of the global tariffs. And so there's some maybe optimism on recent news that may be coming down as part of a wider deal announcement sometime in the near future. We also have India. We get a lot of questions about India. The press is basically saying talks continue to make progress and the progress is going well without too many details on that. But we heard a couple of weeks ago that there's some optimism that India saw or that India is hoping for somewhere in the neighborhood of a 15 to 16% tariff when this is all said and done. Right now we're at 50. Obviously the 25% baseline plus the 25% additional for importing Russian oil. We're going to talk about this. I'm going to skim over this one, but the Supreme Court case that we've been talking about for a while, oral arguments were heard. That's the topic of today, so I'm not going to go into that in too much detail. Other big updates. The last one I'm really going to cover here is USMCA. So thanks for all of you who are attending this, who provided comment through your associations into World Trade Center Utah and submitted directly to the Federal Register for your comments. That closed on November 3rd. But again, the reason these public comments are so important, and we repeat this all the time in these webinars, is that there's some remedy in the future to if these tariffs come out that you provide a comment, and if it wasn't substantively addressed by the government, you have some sort of a remedy or path to remedy to challenge the tariffs down the road. But also, the government may want to hear your voice in this as well and accommodate if you provide input on these tariffs. So really important to have your input into the Federal Register. I know from working with the federal government for years that could be confusing and intimidating, but it's really important to get your feedback there. So only other things that might be worth sharing briefly before we hand it over is just we continue to track Colombia and the threat to Colombia for tariffs. I haven't seen anything new on that. And we have some 232s that we just don't want to say they're going to be tomorrow, but these 232s were released in April and in May. So we have semiconductors, critical minerals, and there was one more that I'm missing. I believe it was jet engines was May 1st when the investigation was released, commercial aircraft and jet engines. And so we want to be sure that those remain on people's radars because we expect to hear something between now and December and January. So keep those on your radars if you're affected by those industries. Be ready to respond appropriately when those tariffs come out. So that's it for me. Tiffany,
Hey, let's
back to you.
turn over to Maggie and Chase. Thanks, Ben.
Thanks so much, Tiffany and Ben. It's really great to be here today to speak about a very exciting time, certainly one of the most exciting weeks in trade in my career. We don't usually get Supreme Court arguments, so we're pretty excited to be here today. We joke that we could probably spend an entire day talking about this, but we won't spend your whole day talking about this. I'm going to share my screen real quick to make sure you guys can see this presentation. So again, as Tiffany mentioned earlier, my name is Maggie Monday. I'm joined by my colleague, Chase Dunn. We're attorneys in the Washington, D.C. office of Cassidy Levy Kent. We also have offices in Ottawa and Belgium. Kind of puts us at the center of these kind of geopolitical trade tensions. A lot going on, as I'm sure you all know. My colleague Chase, as Tiffany mentioned, is from Utah, so I will consider myself an honorary Utahn for today. But yeah, we're excited to get started, so let's dive right in. So as you all know, we're here today to talk about IEEPA, which is the statute that the Trump administration used to justify 2 sets of tariffs earlier this year. To provide a little bit of background, IEEPA is the International Emergency Economic Powers Act, enacted in 1977. Generally gives the president pretty broad authority to regulate economic transactions during a national emergency. Typically, it's been used almost exclusively for economic sanctions, so blocking transactions, freezing assets, things of that nature. The Trump administration is the first one to use IEEPA to enact tariffs. Since it's been enacted. The precursor to IEEPA was the Trading with the Enemies Act, which had pretty identical language to IEEPA, at least in terms of the key language that we'll discuss shortly, which is regulating importation. And that was the statute that the Nixon administration used to justify its 10% global tariffs. Those tariffs were upheld by a lower court, the Customs Court, which is the precursor to the Federal Circuit. But those tariffs never made their way to the Supreme Court. So some interesting context, you'll hear later that the government relies on this Nixon and Trading with the Enemies precedent to support their use and their reading of IEEPA to allow tariffs. But prior to the Trump administration, it had really only been used for economic sanctions.
So as I think Ben noted, and I'm sure all of you know, the Trump administration has imposed or announced a wide variety of tariffs this year. But the 2 that are before the Supreme Court today are come in 2 tranches, right? These trafficking tariffs, sometimes called the fentanyl tariffs, and the reciprocal tariffs. Under IEEPA, the president has to declare an emergency and identify these unusual or extraordinary threats. And so for Canada and Mexico, the threat that was identified is this cross-border flow of illicit narcotics, fentanyl, but also human trafficking and other kinds of things. And the failure of Canada and Mexico to deal with that threat in a meaningful way. China was related to that, given that a lot of the precursor chemicals for these narcotics come from China, but also money laundering and other kinds of things. So the threat for the trafficking tariffs is really limited to those kinds of things. And in response, to deal with that threat, the president imposed a 25% tariff on all goods from Canada and Mexico. There was some clarification that if you qualify under USMCA, the tariffs would not apply. There's been some discussion about maybe the tariffs will go up on Mexico, but nothing yet there. China initially subject to a 10% tariff in February. That got pushed up to 20% in March. And currently, Canada got a 10% increase in August this year. So some movement there. China is currently subject to 20%, but given some announcements in recent days, it looks like that's going to go back down to 10% effective November 10. So on the reciprocal tariffs, the unusual and extraordinary threat was the lack of reciprocity in our bilateral trade relationships and the exploding trade deficit. It's true that we've had a trade deficit for decades, but it's really reached a tipping point here when I think it's increased by 40% in just the last 5 years to well over $1 trillion in 2024. And that has really downstream consequences, right? US manufacturing, the defense industrial base, even agricultural capacity have really taken a hit there. If you look at the executive order, they note that manufacturing represents about 11% of GDP, but it accounts for 35% of productivity growth, 60% of US exports, and 70% of R&D. So the downstream consequences of the trade deficit are real and growing. Additionally, you guys, I'm sure most people know there was a baseline tariff that went into effect in April. You had these higher country-specific rates. They were paused, but really came into effect on August 7th, so-called Liberation Day. But since then, we've seen some special deals. EU and Japan and the UK, and in large measure, have capped some of those duties at 15%. And just in the last few weeks, we've seen some new potential deals and frameworks with some Southeast Asian countries. So continues to move, but I think that's generally the background that you'll need for when we jump in here.
So while we're all here, there have obviously been some legal challenges to the Trump administration's use of IEEPA to enact these two pretty broad tariff regimes. Two pretty interesting points, I think, that are worth flagging in terms of the legal challenges. One, they've been very quick. They've been on an incredibly expedited timeline. So as Chase mentioned, the tariffs were enacted earlier this year, and by May, they were already challenged at the Court of International Trade. And now we're in November, and we've already heard Supreme Court oral arguments. So that is an incredibly quick timeline for a case that is very complicated and a case that's not in the normal wheelhouse of the Supreme Court. So I think that'll be really interesting when we talk about how the Supreme Court is going to deal with these challenges, because if you listen to the oral arguments this week, they're wrestling with some pretty complicated issues, and the remedies are going to be pretty complicated. So this quick timeline, I think, is interesting, and I think it signals that not all the issues are going to get resolved, regardless of how the Supreme Court rules. Another interesting thing to flag is that the decision at the Court of International Trade was unanimous, deciding that the tariffs were invalid. But by the time it got to the Federal Circuit, it was split, right? It was a 7-4 split. 4 justices came down pretty hard on the side of IEEPA being valid, the IEEPA tariffs being valid. And although the majority said that IEEPA didn't authorize the Trump administration's tariffs, they didn't draw a hard line saying that IEEPA wouldn't authorize tariffs at all. So it's pretty interesting. It shows that there's really no consensus on this answer. And by the time we've gotten to the Supreme Court, as we'll explain in a couple slides, it's even more of a split, right? There's 3 justices probably on one side, 3 on the other, and 3 probably in the middle at this point. So it's a complicated issue, and there's really no legal consensus at this point about the authority under IEEPA.
Okay, so this is actually my favorite slide. There's a lot here, but as you know, in addition to the parties' briefs before the court, there were something like 40 amicus briefs, and so briefs by historians, professors, research, think tanks. There are a lot of issues before the court: historical, statutory, constitutional. But what we've tried to do here is kind of narrow it down to 3 primary questions. And I'm going to put on my Trump administration hat and give you the steelman of the yes arguments. And Maggie's going to put on her private litigant hat, and she's going to give you the no arguments. But that'll give you a sense of really the arguments that were raised in the briefs and that were before the court. So I'm going to start with this first question. Does IEEPA authorize tariffs? When Congress enacted IEEPA, they used this language, right? It authorizes the president in an emergency to regulate importation. Now, Congress, under the Constitution, has the power both to regulate foreign commerce and to impose taxes. And going all the way back to the founding of the country, It has always been understood that Congress's power to regulate commerce includes the power to impose tariffs, right? Tariffs are a traditional way of regulating imports. And so the government's argument here is that, look, Congress was eyes open when they used that language. They knew what they were doing. They gave the president the authority in an emergency situation to apply tariffs. We also have a more recent example that Maggie had mentioned earlier, right? Under TWIA, the Trading with the Enemies Act, used exactly the same language, regulate importation. That's the language Nixon relied upon in the 1970s to impose tariffs, and it was found to be lawful by an intermediate court of appeals. Granted, not the Supreme Court, but an intermediate court of appeals did find that that language clearly authorized President Nixon to impose tariffs. And so given the historical background and the more recent background and IEEPA's broad language and giving multiple tools to deal with an emergency, clearly Congress was aware that they were giving the president to oppose tariffs.
So putting on my contrarian hat, what my colleague doesn't mention is that nowhere in IEEPA do you see the words tariffs, duties, tax. Congress has the taxing power under Article 1 of the Constitution, right? If Congress wanted to give away its taxing power, and as it usually does when it is delegating its taxing power, it's clear about it, right? There's other statutes that grant the president tariff power. It uses words like tariff, it uses words like duty. And IEEPA doesn't. None of those words appear. There are lots of verbs that appear in the statute of the things that the president can do under IEEPA. Tariff is not one of those verbs. We could see in the oral argument that this was something that Justice Barrett really struggled with. I think she asked the Solicitor General at one point explicitly, can you point to any other statute that uses the words regulate importation that means tariff power? And he couldn't. He pointed to TWIA, but she was like, besides TWIA. We know that that was there, but that's not on the books anymore. Are there any other statutes that use regulate importation to mean tariffs? And on the other side as well, the liberal justices also really struggled with the text of the statute, right? Justice Jackson said she really cares about the legislative history. And when you're looking at the legislative history, there's nothing in that to indicate that Congress contemplated the president having tariff power under IEEPA. So when we're just looking at the plain statutory text, it's kind of hard to get from regulate to tax, when tax is a congressional power, typically, historically, and constitutionally.
Ben, I didn't know if you had a question for us.
I do have a question. I'd like to interject and just ask, because I'm so curious on this topic. There were some references of the congressional staff language that came out about the intent. It wasn't the letter of the law, but there was some back and forth on that. I'm curious, historically, how much is that taken into consideration? Or can we predict that the court will rely solely on the text and not the intent language that was not a part of the text?
That's a really interesting question. So typically, liberal justices, the liberal faction on the court, looks a lot more at the legislative history and the intent, whereas the conservative justices typically look at plain language, a textualist approach to the statute. Here, I think we could see some of that in the back and forth. Justice Jackson, Sotomayor, Kagan, they all were thinking a little bit more about intent of Congress, but they also were focusing pretty hard on just the plain text and the plain meaning of the word regulate. Whereas it seemed like some of the justices on the other side maybe were willing to look slightly outside of the text, especially when we're thinking about the Nixon precedent. It seemed like perhaps justices that fell more on the side of supporting the government's arguments were more willing to think about, well, did Congress knew that Nixon enacted these tariffs when they enacted IEEPA, and they kept the language from TWIA. So can we take that to mean that they intended for that language and that power to carry over? So it's interesting. It's something we'll talk a little bit about in other examples here, but there's a little bit of a switch on the court in terms of which of the justices are sticking to the plain meaning in the text and which are willing to look outside of that. I don't know if Chase has anything else that he wants to add there.
Yeah, no, I think that's great. I think some of the originalist judges or justices we'll focus on the text, but we'll kind of look at the legislative history as kind of the last question. Well, is there anything in the legislative history that makes our understanding of the text, inconsistent? So they may look at it, but I think Maggie's right. They put a little bit less emphasis on it than some of the more liberal justices. So if we move to the second set of questions, right, whether IEEPA authorizes the trafficking tariffs. President Trump followed IEEPA's requirements by declaring a national emergency. We talked about the trade deficit. We talked about the fentanyl crisis. These are unusual and extraordinary threats, right? They may have existed in the past, but they've really reached a tipping point, right? And there wasn't really much discussion or even pushback from the justices during oral argument about this particular issue. They seem to be really, unwilling to kind of address whether there was an emergency or not. The tariffs here address the threat, right? President Trump imposed these tariffs in order to deal with the trade deficit, in order to deal with the fentanyl crisis. So the tools that Trump is using have a direct relation to the emergency. And we don't even really have to question whether or not the tariffs are going to work as leverage or work as an incentive to change the behavior of our trading partners, because we already see it. We've seen trade deals with China, with the EU, with Japan, with the UK. So using tariffs as leverage to get our trading partners to change their behavior, it's already working. So we know that we've declared a proper emergency. We're using the tariffs to deal with that emergency, and they're working. And again, under IEEPA, remember, it's an emergency statute. Congress is wary of limiting the president's authority in an emergency situation, because you can't predict what emergencies are going to arise or what tools the president is going to need to deal with that emergency. So not only has the president followed the requirements of IEEPA, just IEEPA's kind of general structure supports a reading that the Congress was authorizing these broad tools to give the president some leeway to deal with whatever emergency that might arise.
Yeah, so it's interesting because I think that these arguments got a lot more airtime in the lower courts. They didn't really come up a lot. And I think that leads us to believe that maybe the Supreme Court is not trying to parse the details or the specifics of the tariff. They want to know more about the statutory issues that we just talked about, or the constitutional issues that we'll talk about in a second. But these issues do give color to those kind of broader overarching issues, right? So how much power Congress is delegating to the president, whether these specific tariffs are an overreach in that power that may or may not have been delegated. So for example, with the trafficking tariffs, the lower courts had to deal with this kind of for any other purpose language. So the idea that the response that the administration takes under IEEPA can't be for any other purpose than fixing the national emergency, than responding to the national emergency. And we did hear a little bit in the oral argument about the idea of whether the tariffs themselves were responsive to the national emergencies, or whether they were solely revenue raising. And I think that, if we look at the president's own words about the purpose of these tariffs, he's pretty clear that the purpose of these tariffs is to raise revenue. And if the purpose is to raise revenue, then they are a tax. And if they're a tax, then that's violating, pretty clear separation of powers. As I said before, taxing is a congressional power. And if these are revenue raising tariffs, that language was parsed a lot during the argument, whether the revenue raising function was the purpose of the tariffs, or whether that was just a fortunate byproduct. I think that is something that the justices are struggling with.
So, and that's great. And so that kind of goes to the next set of questions about the constitutional issues, right? And the government was very clear that the only reason the private litigants are kind of raising these kind of ambiguous constitutional doctrines that a lot of people have never heard of is because they think their arguments are weak on the statutory frame, right? And so if you're the Trump administration and you're arguing on the major questions doctrine, which essentially says when the executive claims power to decide an issue of vast economic and political significance, the courts are not just going to defer to the executive or the executive's interpretation unless Congress has really been clear about the kind of authority that it's delegating, right? But here, the president has his own Article 2 foreign affairs power and national security power. And in those contexts, the courts have always granted the president a lot of deference. So in this context, when you're talking about foreign affairs, national security, the president is supposed to get a lot of deference in his interpretation of statutes and the authority that's been delegated, right? And again, if you go back, IEEPA clearly is granting this power to the president. So IEEPA authorizes the president, for example, to prohibit or embargo another country. So you could stop imports entirely. Well, if Congress was granting the president the power to embargo a country or to prohibit all imports, it would seem a little odd that Congress was not okay with giving the president a lesser tool, a more narrow tool of imposing tariffs to address a national emergency, right? Under the non-delegation doctrine, a similar issue, right? Under the non-delegation doctrine, Congress cannot transfer its constitutional authority to the executive without providing very clear, intelligible principles about how that power is supposed to be carried out and what the limits of that power are. But here, Congress did that, right? The president cannot just impose whatever tariffs he wants without any background. The president has to impose or announce and declare a national emergency. The tariffs or the tools have to be designed to address that national emergency. And again, Congress can terminate that national emergency whenever it sees fit. So there's no non-delegation problem here, right? There are guardrails. The president followed those requirements under IEEPA, and if Congress disagrees, they can certainly pass a resolution that would end the national emergencies, which would end the tariffs immediately. So there's not, from the government's perspective, the major questions doctrine doesn't really apply here. And even if it does, Congress was clear. And the same with the non-delegation doctrine.
So on the other hand, a lot of the justices really struggled with these two major constitutional issues. The major questions doctrine was something that came up from Chief Justice Roberts a lot. He was really worried about the ramifications of ceding this kind of like vast economic and political power to the president without any sort of boundaries. He said, I think at one point, how are global tariffs that are not limited in scope and not limited in duration, how are those not going to have vast economic or political consequences? We already see that they do, right? They've raised $90 billion plus in revenue. If that's not economic significance, then I don't know what is. So that I think is something that the justices, especially that kind of didn't tip their hand either way, are really struggling with. Similarly, with the non-delegation doctrine, Justice Gorsuch almost explicitly said that will be the winning argument for him, right? One way or the other. Has Congress ceded too much of its power to the executive without any sort of boundaries? He talked about at what point does it end, right? At what point does Congress give away all of its power? And once it does, how is it going to be able to claw that back? In 1977, maybe Congress could have envisioned being able to get that power back from the president, but today I don't know if that's possible. And I think that he really struggled with that as well, especially we're in the midst of a government shutdown in Washington. How is Congress today going to claw back power if it needs to from the executive? So these two issues, major questions and non-delegation, seem to really be bothering some of the justices that might fall sort of more in the middle at this point. So that kind of takes us to the next issue, which is what is the Supreme Court going to do? How are these justices going to fall at the end of this?
Yeah, and this was kind of our guess about kind of where the justices stand. But I think it's pretty interesting, and it's important to kind of pay attention to some of the more recent cases that have come down, as Maggie mentioned earlier, right? So for the liberal justices, for example, in the recent Biden student loan case, Kagan and the liberals argued for a very broad reading of ambiguous text, right? Remember, the HEROES Act authorized the Secretary of Education to waive or modify certain regulations as it related to student loans, and the liberal justices said, come on, waive and modify can clearly mean canceling or or getting rid of student debt. That's a reasonable way to read that statute. Whereas here, they seem to much more skeptical that the term regulate importation could allow for tariffs, notwithstanding some of the historical background. So I think the liberal justices are going to be, it's going to be difficult for them perhaps to maybe square their position in the Biden student loan case with their opinion here. But equally so on the far right, Justice Thomas, Alito, and Kavanaugh had kind of the opposite problem, right? In the Biden student loan case, they were, very clear. Waive and modify does not mean canceling student debt, right? Even though waive seems pretty close to canceling, but Justice Kavanaugh even noted Congress didn't use the term forgiveness, Congress didn't use the term cancel, and we can't read an ambiguous statute to just allow the executive to do whatever it feels like or rewrite the statute itself. But here, Kavanaugh and Alito in particular seemed much more willing to regulate importation pretty broadly to give the president maybe authority that Congress didn't specifically, use those magic words, tariffs or duties. And so I think actually both sides are going to have some difficulty kind of squaring some of their opinion in the Biden student loan case with their opinion here. And Maggie touched on, I think, really the key issues for the swing votes, right? Justice Roberts, the chief, almost immediately he was asking about major questions, right? He really wanted to know, did Congress really give this authority? Where does it say that? Was it clear? Was it, especially given the constitutional issue here that Congress has that constitutional authority to impose taxes, right? There's a law, the revolution in many ways was about taxes, right? And who gets to impose them. So when you start giving that taxing power away to the executive, you really want to make sure that it's very, very clear. Gorsuch, again, non-delegation seemed to be his issue. He was very concerned about kind of the ratcheting of that power over to Congress or to the president, and with no ability to kind of get it back. And so, Barrett was really interesting. Barrett, in the first hour, seemed really skeptical that IEEPA would authorize tariffs, right? Again, as Maggie noted, she asked, give me one example in history where Congress ever used the term regulate to impose tariffs, right? The FCC can regulate communications. The SEC can regulate securities. Nobody thinks those two agencies can be imposing taxes or tariffs, right? So she seemed really skeptical at the outset, but in the second hour, she seemed a little bit more willing to think about, well, maybe the tariffs are just a license. So IEEPA authorizes the president to impose licenses, right? And maybe the tariffs could function as a license to enter the US market, right? Is one way to maybe read that term license. So she was really engaged with the text, but at the first hour, I thought she was kind of anti-tariff, and at the end of the oral argument, I wasn't so sure. So, but I do think these are going to be the key justices to watch in the middle, right? I think these are going to be the swing votes, and if the liberals can pull over two of them, Maggie and I were talking, we suspect you're going to see one of the conservative justices write the opinion. Because it would mean a lot more if it came from a conservative justice. So that's kind of where we landed in terms of where the justices came out on the oral argument. It was only scheduled for 80 minutes, but it went 2.5 hours. So if you haven't listened to it, it's actually a very engaging and accessible oral argument. So I would encourage everyone to kind of take a listen.
Now I think moving on to what most of you are probably here to hear about, what is the Supreme Court going to do? I think as Chase just narrated, it's hard to say at this point. And I think it's interesting that it's hard to say, that it's not clear cut, and that a lot of the justices didn't really tip their hand at the oral argument. So we've narrated here some options that we think of what the Supreme Court could do. 3 of those options would mean that CBP, Customs and Border Protection, is going to have to start thinking about issuing refunds of all of the duties paid. So if the Supreme Court finds that IEEPA either doesn't allow tariffs at all, that even if IEEPA allows tariffs, they don't allow these tariffs, or that if IEEPA does allow tariffs, that is an unconstitutional delegation of power. In any case, CBP is going to have to start thinking about refunds. And as Justice Barrett said at oral arguments, it's going to be a mess. I'm sure, as any of you know that have to deal with CBP in any capacity, it's going to be a mess. It's going to be difficult. So, that I think is something that the justices are struggling with. What is that actually going to look like in practicality? I think regardless though, if option 1, 2, or 3 do happen, the Trump administration has signaled that they have other tools in their back pocket, which Chase will discuss shortly, that they can pretty quickly pivot to, right? Other statutes that allow tariffs that the administration can pivot to tomorrow if they need to, right? So I don't think tariffs are going anywhere. I don't think the Trump administration would concede defeat with IEEPA and back off of their bigger tariff policy agenda. So it's important that importers don't kind of become complacent and think even if IEEPA goes away, that doesn't mean that this broader tariff regime is going away. And then on the other hand, the court could find that IEEPA does allow tariffs. I think that is a very real possibility as well. It would maintain the status quo in terms of IEEPA duties, but as you all know, the status quo is changing every day. So even if that is the case, the Trump administration will probably use that to go back to all of the trading partners and re-up negotiations again. So those duty rates could change as well, even if the Supreme Court upholds IEEPA.
Yeah, and thanks, Maggie. And so, here are some, I think really the meat here is going to be on the executive action side. I think that's what you're most likely to see. Sounds like many of you are aware of Section 232, Section 301. These statutes give the president the authority to impose tariffs, but there's a lot of procedural hurdles, right? You can't just impose tariffs on every country on the planet. You've got to, usually these are very narrow, focused on like steel and aluminum or specific products or specific countries. We've had Section 301 tariffs on China since the first Trump administration. So there's certainly, those two statutes could be used, but they're slower, more piecemeal, and so wouldn't be as nimble of a tool for the president to use. Section 122, this is a statute that is specifically designed to deal with balance of payments issues. So from the reciprocal tariff side, that would be a statute that could be used, although it's never been used to date. And this was passed right after Nixon imposed tariffs in the 1970s to deal with that exact problem. So wouldn't affect the trafficking tariffs, but would be a way to deal with the reciprocal tariffs. Section 338 got brought up during the oral argument. And so I was kind of surprised to see that. It is a statute that allows the president to impose up to 50% duties or block imports from countries that have discriminated against U.S. commerce. But that section was not mentioned in any of the executive orders. So there's some, it'll be interesting to see how the Supreme Court addresses whether it can rely on other statutes, even if they weren't mentioned in the executive order. And again, the whole licenses, right, IEEPA, the executive could come out afterwards and just say, well, we're going to issue a new executive order and say these are all licenses instead of tariffs. And so, then it'd have to go all the way back through the courts again, right? On the congressional side, I think these are more unlikely to be avenues, but we wanted to flag some of them, right? Congress could ratify these recent trade deals that the president has been engaged in. They could modify IEEPA and just modify the language and make it clear that they meant tariffs. They could modify other trade statutes, relax some of those procedural hurdles. Fast track delegation, this is kind of an interesting one. It's possible you could envision something like the Congress saying, yes, the president has authority to impose tariffs for 90 days, but those tariffs sunset unless Congress affirmatively approves them. Something like the War Powers Resolution, right? So these are just some of these examples that could happen on the congressional side, but our guess is probably unlikely. More likely, the Trump administration is going to look at prior existing statutes to maybe deal with whatever SCOTUS decision that they get. And this may not be new to many of you, given World Trade Center Utah has this great dashboard, but as you can see, this is the much broader tariff landscape, right? The IEEPA tariffs are part and parcel of a much broader landscape. 232, we've had tariffs on steel and aluminum and derivatives. Those have been extended. You've got all of these potential tariffs on semiconductors, pharmaceuticals, robotics, UAVs, and those kinds of things. There's been a 301 on Chinese shipbuilding, although with the recent discussion of a potential deal with China, it's unclear kind of where those are going to go. Again, we've had 301 on products of China since the first Trump administration. The two things I do want to flag on the right-hand side of the screen, though, the USMCA is up for a review in July 2026. It's possible that you could see trying to deal with the trafficking tariff issue through the USMCA review. So it's something to keep your eyes on for the next year. The anti-stacking, this is a very complicated part of the tariff landscape. Sometimes the tariffs build on each other. You might have 301 and 232 and IEEPA, or in some cases, maybe 232 applies, whereas IEEPA doesn't. In other cases, 232 would apply to the steel and aluminum content of the imported article, but the IEEPA tariffs might apply to the remainder of the value, right? So figuring out the value of your import and how much of it is steel and aluminum, how much of it is not, can be really critical to maybe mitigating your tariff liability, right? So understanding the stacking rules are extremely important, and those, it's a very complicated space, but it is something that you should be aware of as you think about this broader tariff landscape.
So thanks, Chase. That's great. And I think that that leads us right into what is hopefully the most helpful part of this presentation for you all, which is what do you do, right? In this trade landscape that is changing every day, we know and we talk to businesses every day that are incredibly stressed out trying to understand how they operate in this new world. So there's a few options that we wanted to lay out for you. We have an office of over 40 trade professionals in Washington with decades of experience dealing with all of these issues, navigating these kind of changing trade winds. So, these aren't the only options, but these are the ones that we hope will be helpful to walk through, at least in the short term while we're all together here. So one of the main immediate ones is considering preserving your refund rights if IEEPA is decided to be invalid or unconstitutional. That's important, and that's something that we need to start thinking about today, right? We're currently counseling clients about the best ways to preserve their refund rights. We're actually unique in that we have some in-house customs brokers in our law firm, as well as a former branch chief of CBP. So we have people that are experts in navigating this space, and we're able to pull information from ACE, the Automated Commercial Environment that CBP uses to track import data. One of the things we regularly do is we pull these import reports from ACE, and we're able to see the entries that you've paid IEEPA duties on, and we can see the liquidation status, most importantly, so that we could pinpoint when and how to start preserving refund rights, because that will be pretty critical, I think, because it will be a mess, and that's something I think that we want to be proactive about in the short term while we're waiting on the Supreme Court to issue a decision. The second big thing to keep in mind that I'm sure you all know is that the tariff landscape is changing every day, right? Every day, every night, I feel like I go to bed and I wake up and I have 20 new notifications about different policies that have been changed or enacted or announced. So one of the things that we do at CLK is we have some international trade specialists and other professionals in our office that track and monitor all of these developments, and we send at least weekly client updates to help clients kind of navigate all of these issues, all of these changes, and we can provide, customized insights based on, we have clients that we know are really interested in, for example, the steel derivative inclusion request process. So we're able to kind of help those clients be proactive instead of reactive to these new changes to the tariff landscape. Third, mitigation strategies. Chase kind of touched on this. There's some pretty big issues that are important for importers to consider. So like valuation is one thing. We have experience pretty regularly advising clients on how to make sure they're, one, being compliant with customs regulations, but then also making sure that they're not overpaying their duties, that they're not seeing unnecessary duty liability. So for example, things like breaking out international freight out of valuation, making sure you're using the right HTS classification so that you're not paying duties on items that you don't need to be paying duties on. We also regularly advise, large multinational corporations with hundreds of subsidiaries on supply chain and trade flow tracking, again, to make sure that these clients are both compliant, but then also are using all of the mitigation strategies that are available in this landscape of multiple different tariff regimes. And finally, I think advocacy and lobbying are something that we're very passionate about for our clients. We're here in DC. We're on the phone with White House officials every day, Commerce Department officials, USTR. We try to make sure that our clients are proactive instead of reactive. There's lots of avenues to do that depending on your interests. So exclusion or inclusion requests for these different tariff regimes, 232, 301. And then for domestic producers as well. We represent a lot of domestic producers who are interested in understanding how to leverage a presidential administration that really wants to make sure that domestic manufacturing is strong. And there are a lot of avenues to kind of level the playing field and take advantage of an administration that is willing to leverage these less used tools in the executive toolbox. So all of that to say, it's a lot of information, but we're happy to answer any questions you might have about IEEPA, about strategies, about what's next. We can answer questions today or offline. Our contact information is below. We look forward to helping you navigate this kind of crazy world that we've all found ourselves in.
Well, Maggie, Chase, thank you so much. And thanks everyone for your attention today. I know this is really complex issues. We do have a few questions that have been added. So starting with Paul Campbell, if the Supreme Court rules against the Trump administration IEEPA authority to impose the tariffs, seems the administration has other plans to claim tariff authority. What's the practical outcome if the Supreme Court does rule against the administration?
Yeah, that's a great question. So practical outcome on the one hand is CBP is going to have to start thinking about refunds. It's not clear yet how they're going to do that, if the relief from the Supreme Court case will be limited to those plaintiffs or whether CBP is going to have to, as a matter of course, refund all duties. So that's something that we're advising clients now to start thinking about preserving refund rights. And then, for the second part of that question, other tools in the toolbox, I think Chase did a good job of speaking to this, and he can probably speak on it a little bit more. But, the Trump administration has already said they have a lot of other tools in their toolbox that they could use pretty immediately. So Section 122 to deal with the trade deficit, or Section 338, both of those would allow the Trump administration to enact tariffs pretty quickly. Chase, I don't know if you wanted to elaborate on any of that.
Yeah, I think all of that's great. The one thing to keep in mind, though, is that the Supreme Court may issue a decision about whether the tariffs are lawful or not, but not issue a decision about the remedy. So that the decision about whether refunds would be given, when refunds would be given, to whom, when, that process, that is very likely to be sent back down to the district court, the Court of International Trade, and to have to fight that out another day. So my hunch is that if the Supreme Court rules that the tariffs are unlawful, they're unlikely to make a decision about whether or how those refunds are going to take place. And so just bear in mind that it's possible that even if the tariffs are found lawful, that no refunds retroactive are granted, but no tariffs would be collected prospectively. That's a really complicated question, and some recent Supreme Court cases that we'd have to get into to kind of walk through that. But that's the only thing I would want to flag, is that even when we get a Supreme Court case about the tariffs, we may not really understand how to deal with refunds or what that might mean for other importers.
Thank you both so much. Next question is, can you expand on licenses instead of tariffs? Heard that before and am unfamiliar with how that would work.
Yeah, it's really interesting. And I think that it's something that the lower courts didn't really wrestle with as much as it seemed to come up, especially with Judge Barrett. It's interesting because licenses are more of permission to import, right? Whereas tariffs are traditionally a tax on importation. But the question is, could the Trump administration kind of rejigger their tariff regime and make it into a license and say that the value or the tax or whatever on the import is really just a license by any other name. And it sounds like maybe Justice Barrett and maybe some of the other justices could buy into that argument, because the statute does explicitly mention licenses, and licenses could have a fee. But does that mean just a nominal fee? They went back and forth on that a little bit. Is it a fee just to cover the cost of the government, or can you actually incidentally raise revenue from the fee for the licenses? Chase, and I think that you had something else you wanted to add.
Yeah, I think that's exactly right. The only thing to note there is this is keying into a case that dealt with Section 232. It's called Algonquin. It was a 9-0 decision. It's a little bit dated at this point, but in that case, 232 explicitly talks about license fees. And so one of the questions is, how relevant is the Algonquin case on Section 232 to IEEPA, given that IEEPA does mention licenses? 232 also talked about license fees. And so that's kind of where that language is coming from. That's why it got brought up. And Justice Kavanaugh, I think in particular, noted that, look, Algonquin is very important to this case. And so at least he and some of the others were very interested in whether you could talk about a tariff being, a license fee to enter the U.S. market.
Well, I think that's it for questions for today, but Ben, do you have anything? Actually, let's let you take it.
Yeah, I have a.
Really sitting here wanting to ask questions.
Oh, I have I'm going to use this time if I can, point of privilege for being on the panel. I just get to like raise my hand anytime I want. But I'm curious what your guys' take is on this, because it seems to be a major piece of how the decisions will be swayed. There's a lot of discussion around raising revenue. And if you're a business, you hear revenue and you hear money in. But it sounds like the government has a different definition of revenue, which is almost more like income or profit. And so, meaning that if you're doing cost recovery with these tariffs, maybe there's a little more wiggle room on what you're trying to do. If you're trying to profit and fund other things, maybe not so much, right? So I'm curious what your guys' take what your take is specifically on. I wonder if there's some justification here that is going to be pressed or decided in an outcome that's more or less, running a deficit and needing and hollowing out our defense industrial base has real costs that these could offset. Is that too broad of, well, that's income generating to fund those activities? Or how I'm curious what your opinions on that particular issue are.
Yeah, I think, and so it's an interesting question. If Congress delegates the power to the president to impose tariffs, then there's no real problem with the revenue raising stuff, right? Section 301 raises revenue, Section 232 raises revenue, right? So nobody appeared to dispute that Congress can't give the president the authority to impose tariffs that have a revenue raising effect. So the real question is, does IEEPA give that kind of authority, right? Maybe it's too ambiguous, maybe it's not. But the Trump administration offered something that I thought was rather curious, and I'm not sure how it's going to play with the justices, but during the oral argument, they were adamant that these were regulatory tariffs, not revenue-raising tariffs. And they tried to make a distinction about, well, we're just regulating commerce, and if it has this incidental effect about raising revenue, okay. But as Maggie mentioned, the president has often gone to Truth Social to talk about all of the revenue that we're raising from these tariffs and how great it is. So there's some kind of dispute there about what is the purpose of the tariffs. But yeah, it's an interesting question about whether the tariffs could be thought of as just offsetting the costs from the trade deficit, or for example, the fentanyl tariffs, right? It's a public health emergency. It's costing the United States a lot. Hundreds of thousands of Americans are dying because of it. the tariffs maybe could be thought of as a way to kind of offset the cost on the healthcare industry or offset the cost for the manufacturing industry. It's an interesting thought, but I'm not sure how the Supreme Court would actually grapple with that.
Yeah, I think it's really interesting. I think one of the more interesting analogies that was drawn during oral arguments was the idea of a national park, and say Congress gives the president power to regulate entry to a national park. Don't we think that would include an entry fee? And even if that entry fee is high enough that the government would, make a profit off of it, do we really think that Congress wouldn't contemplate part of regulation being an entry fee? And are tariffs just an entry fee into American commerce? I think that's interesting. It was hard to tell what side the justices will come down on that. We heard from some litigators who have argued in front of the Supreme Court before and that filed briefs in this case, and they said, it's interesting that this was a trade case that became a tax case. And yeah, I mean, I think it's just it comes down to the fundamental question of whether you can buy into the idea that tariffs that generate, $90+ billion of revenue, if that revenue is just incidental to the regulatory function of the tariff, whether tariffs can be regulatory at all. And the arguments about, well, you can have an embargo, but you can't have a 1% tariff. And I think the Solicitor General said a couple of times, well, these tariffs would be most effective if we didn't make any money from them at all, because it would mean there were no imports coming in. So does that lend credence to the idea that these are more regulatory in nature than they are revenue raising? I don't know. It's interesting, and it's interesting that the president's line has been touting how much money the tariffs have made, and then you hear the Solicitor General talking about, well, that's just it's just the byproduct, a fortunate byproduct of these tariffs. There seems to be some discordance even in the position the government is taking about the purpose of these tariffs.
I see a question just on a ruling. As Maggie mentioned earlier, this is an extremely expedited briefing schedule. It was very fast. There's no way to predict, but my sense is probably early in 2026. I wouldn't expect this decision to carry on too far into 2026. But
That's usually June,
soon.
I think, but I can't imagine they're going to wait till June.
Yeah, I think that's right.
Well, thank you so much. And apologies, right as I'm closing, I have lawnmowers outside. Papers. Really, thank you so much, Ben, Maggie, Chase, today. Maggie and Chase, thanks so much for joining us. We covered a lot of ground today on this complex topic, and just really value this opportunity to partner with you guys. You guys have just been absolutely wonderful to share your perspective and just help Utah businesses navigate these challenges. You guys have been in an intense period the last little bit too, and so appreciate it. Chase, it's nice to have you home with Utah, and then having Maggie as our honorary Utahn today as well.
I know. I've got to make my way out to Utah now. It's a great excuse to take a
Exactly.
trip soon.
And thank you guys.
We'd be happy to host you. And then we will be sharing these slides with everybody, but if you guys have any additional questions, don't hesitate to reach out to World Trade Center Utah. We'll also, with the slides, we'll be able to share Chase and Maggie's information as well. But really the key takeaway in this is that uncertainty is really the only thing that's certain right now. So that's what we can do is to stay informed. And we appreciate everyone joining us today. If you missed any part of today's briefing and want to catch up on it, it is on our YouTube channel, and that's dropped in the chat. So thank you, everyone. Have a great weekend.
Thank you.
Thank you.
Bye.